Hello again. It's John Crotts, attorney at King Law and elder law specialist. Wanted to talk to you a little bit today about how to contest a will. This comes up from time to time, and you know, there are a limited number of ways to challenge a will, and sometimes this comes up during the course of the planning process. Someone will ask me, now, is there any way somebody could try to challenge this later? Um, and we'll discuss the probabilities and possibilities associated with that. But more commonly, it comes up after a loved one dies and someone's unhappy. Um, Maybe they legitimately think that there was some shenanigans involved in the process and how their loved one made this will. Um, or maybe they're just hurt that their loved one did not leave them what they feel like was a fair share of the estate. So it can come up in a number of different ways. The first thing that's got to happen is someone's got to produce a will and file that with the court and attempt to have that will probated. Probate is that process you go through to try um, to have the will approved by the court and to get the inheritance distributed to the heirs after creditors are paid and so on. Well, once that will is admitted to the court for probate, any interested party can file what's called a caveat. That's what we call them in North Carolina. It's a caveat or a will contest. And there's a special pleading legal papers that have to be filed. And that basically puts a freeze on the estate and turns it into litigation. The case gets transferred from the clerk of superior court, who oversees estates in North Carolina, and gets sent up to the Superior Court Division, where the case is docketed by the trial court administrator for jury trial. So it's no longer just an estate, a transactional process, but it's now litigation, and we're going to court. And the first thing that happens once that caveat gets filed and everybody gets served and notified, and those kinds of things, there's what's called an alignment hearing. And that's when the court's basically saying, anybody that's got any business in this estate, come to court now and tell us which side are you on. Are you in favor of the will? And we call those the propounders. And then, or who is wanting to challenge the will? Who believes with the challenger that this will needs to be set aside for some reason or another? And we call those, or that group, the caveators. So the caveators and the propounders, some weird, funny legal names, basically the challengers and the supporters of the will. After that, the court requires the parties to go through mediation, which is required in a lot of legal proceedings. And it's actually a good thing. As a certified mediator, I believe strongly in mediation and trying to resolve those conflicts out of court where the parties maintain control over the process. May do a separate video on that one day, but so the parties have to go through mediation, see if they can work this thing out. Believe it or not, most cases do, in fact, settle through mediation. Most caveats or will contests settle through mediation because as the fight goes on, guess what? Guess who's paying that expense? Well, oftentimes it's coming out of the estate. Sometimes the parties are paying some of that out of pocket, but the court can actually require both sides' expense to be paid out of the estate if there was a legitimate dispute there. So the sooner the parties can resolve that, the more savings they may experience, and there's more to go around for everyone. But if they can't work it out at mediation, all the different pre-trial civil processes are available: depositions, discovery, interrogatories, and all the different things that go into the civil litigation process. And then after that, they go to court and there's a jury trial. And sometimes those cases will settle the day before court or during the trial itself, or even after the trial. But if they can't work it out, it goes to jury trial and the jury decides whether the will stands or it gets overturned. Just a few reasons that the court or a jury can overturn a will. The most common is incompetency. If the person who signed the will didn't really know what they were signing due to some cognitive impairment, dementia, Alzheimer's. There were under the influence of medication or something of that nature. Um, Duress, coercion, somebody forced them to sign a will, against their will. Could be forgery. Maybe the will, that's not really their signature, and we got to get handwriting experts involved. Uh, Maybe it wasn't by force, but there was just excessive pressure by family for the loved one to sign that thing, and what we call undue influence. Uh, so, and maybe the will itself, the document itself, doesn't comply with North Carolina law. Maybe it didn't have the required number of witnesses. You got to have two. Maybe one of the witnesses was an interested party. Maybe it was a relative. Maybe they stood to inherit. Well, you can't be a witness if you stand to inherit from the person making the will. So a lot of different reasons that you can challenge it, but oftentimes I find that people who want to challenge the will, they don't really have a case. They're just, kind of disgruntled and upset that they didn't get what they felt like they were entitled to. But a lot of times there are good reasons to challenge it, and that's something that we do with regularity here at King Law. And so if you got questions about uh, will caveats or challenging a will or some kind of dispute you're in concerning an estate, then we'd be happy to help you out. You can check us out at kinglawoffices.com. And if we can be of further service, let us know. Until next time.